Good evening, everyone. Very warm welcome to uh, Logical Talk 2033. Today, we can say we are kind of closing the loop of 2 year loop, and we are doing the 23rd webinar in the series, uh, continuously for all the months together. Uh, and today we are back with a very interesting topic, and I'm very excited to also tell you all and share with you that today. Um we've got one of the highest registrations for any logical talk, which shows how important and how critical is this subject for everyone today. Anybody who's in the corporate and the legal field, or I would say the technology, uh, data protection is in a way giving a nightmare to many, and we want to ensure that we are ready for the same. Uh, Before I get on to the subject, let me do my customary slide, and I can see there are a lot of people are still joining. Our it's buzzing very fast right now. The numbers are increasing, so I'll do a bit this customary slide, which again I would say most of you are already aware. You've been attending these webinars and these sessions for over a long time. I'll talk about what Lawrbit is, what we do, and then I'll go on to our introduction of our speakers for the day. Uh, Lawbit is a leading regulatory technology company. We offer regulatory compliance management solution, which is our prime software. Is called GCMS, Global Compliance Management Solution, which takes care of regulatory expectation, not just for India but across the globe. We have done projects in 70 plus countries. We are serving more than 450 entities, and we have mapped around 4 to 3,000 plus locations in the software, and been used by more than 12,000 users across not just India but globally as well. We have a team of lawyers and tech professionals, around more than 90 people who are working with us and helping uh, create the India and global regulatory intelligence, keeping it updated as and when the changes are happening in the law, and ensuring our clients are always up to date with the changes in the law and understand how it impacts the compliances. It's a software which is in the hands of the board, which gives you all comfort in terms of knowing what are your regulatory risks. And Logical Talk um, is uh, is a series as a part of our effort where we try and increase the awareness about different laws, and specifically those major changes, major laws which are impacting our lives today. So, very again, welcome to this session today. Sunira and Pooja, hi.
Hi, Ajay.
Hi, Jen. Hi.
Hi, Pooja. Great. Thank you so much for being here today. And again, as I said, the way the people are logging in right now, it's the way it's buzzing. I'm very excited. And we have received more than 600 registrations while we checked
Wow.
the last, and there I'm sure there are a lot many more which would have come in the last hour as well.
Mhm.
And let's get started. And while people are still joining in. So let me start with a quick introduction about our panelists today. Neera, Chandak, you already know, and I'm sure if you have done the registration, you would have had a chance to look at our previous webinar on the similar subject more than a year ago, when the regulation, the act, the bill was introduced. We did a very detailed discussion on the subject then, and we have also encouraged all our users to have a look at that webinar. So Neera had taken up that discussion also for us. And she is the head of legal and compliances for TBO Tech. Again, I would say Neera is a great friend and we know each other for many years today. And I always found a lot of interesting discussions when it comes to compliances, not just for India but globally, and the kind of perspective she brings in. And today she is managing compliances for globally for TBO Tech, and more than 15 countries is where the TBO has its presence, and they are operating in more than 100 countries. Neera, very excited. Your inputs will definitely add a lot of value to all of us. Uh, Welcome.
Thanks,
And
Jen. Thanks for the wonderful introduction.
and we also have with us Pooja Deshpande. She is head of privacy head of privacy consultant in with IDFI. Pooja comes with a lot of experience with the Big Fours and now with IDFI, and she brings a very different perspective from the other side of the table, where she has an experience of interacting with a lot of corporates, understanding the real life challenges and what practically challenges the organization is facing, and what are the real life um, solutions for those scenarios. And Pooja, while we have a lot of we have done a preparation and we have we know what to talk, but I'm sure there are, while we are in the discussion, there will be a lot of queries which will come up, and I'm sure we will try and address those queries through your practical experiences, and looking forward to this discussion. Let's move
Absolutely,
to the
and
next section.
look forward to it.
Thank you, Pooja. So what we are going to cover today, so very quick and check on the timelines and state applicability of state, and because there were a lot of queries also which came in on this particular topic, topic also as to when the rules will be notified, from then they'll be applicable. So we'll talk about the timelines while there are unknowns for us also, but we will share what all we know so far. Talking about the ecosystem of DPDP regulations and the role of key actors, because knowing these key actors are very, very important, understanding what role they are going to play and who they will be. And then we move on to the key provisions of the new rules, which is notified. And again, we just want to also be very sure that it is not the rules and notified, that it's basically the draft regulations which have been notified, and the public feedback and consultation is still going on. But I would say this forms a larger framework as to how things will look like. So we'll have a discussion on that. And talking about the consent manager framework, I mean, very, very important aspect to understand. Implementation strategies, how business really need to be ready for it, because that's a question on everybody's mind. And I think I've received multiple questions in a multiple different language, talking about their industries, their practical challenge, but ultimately everybody is more interested to understand, what do I do? And and impact on the businesses and the implementation strategies and plan. How do you should go about, what kind of a timeline you should look at, and some of our key concerns and summaries, which of basis a lot of discussion with the users. And then we'll try and take a Q&A. But I'm sure during the discussion also we will try and address many of those questions. And you already know, and as I said, this is 23rd session in the series. You already know we try and make this discussion very lively and interactive. So keep sharing your queries in the chat session, so that if there is something which is relatable to that particular discussion and slide, we would try and address it right there itself. Sunira, I would request if we can start the discussion.
Sure, Jen. Okay, thanks, Jen. So, I think everyone is well aware when this journey was started. So, it started in 2017, and in 2023, we got our final DPDP Act passed. And in 2025, we got the draft rules now for our feedback. And that timeline is over, and we can expect the final version. But what is there in the Act initially? And that's basically the applicability of the act that remains the same, that which covers, there are two parts of the processing of digital personal information data. One is processing within India, another is processing outside India. So when the processing of digital personal data is happening in India, it refers the collection of data in the online form, or if it is not in the online form, then it is digitized at a later stage. So this act will be applicable for the processing of online data, whether in, even if it is in offline form but digitized at a later stage, then the act will get applicable. On the other side, if the processing of digital personal data is happening outside India, in that case, but for the activities or for the purpose of offering goods or services to the data principals in India, in that case, it will be applicable. So this is the jurisdiction, the overall applicability. Next is when it is not applicable. It's very when an individual is collecting the personal data for some personal use or domestic use, or a person or data principal itself making his or her data available to the public, maybe through social media profile or something, in that case, this act will not be applicable. Uh, that's the broad framework of the applicability. So these are the key players that were introduced in the act, and as how. And again, those who are not aware, for them only, I'll just give a glimpse of their role in the whole ecosystem of Data Protection Act and the rules. First is the data principal. It's the data. This is the person whose data is under the scope, which has to be kept confidential. So data principal is basically the data owner. And this whole act is basically to provide security or confidentiality of the data to the data owner, basically. Second is the data fiduciary, to whom the data will be provided by the data principal for processing of the data to provide the goods and services to data principal. So data fiduciary is the one who is collecting the data of data principal. So he is the one who is actually managing or controlling the purpose and processing of the data. Consent manager is the one who is acting on behalf of the data principal, basically managing, withdrawing, applying for the consent on behalf of the data principal. This is a unique concept which has been introduced in the Act and further elaborated in the rules now. Then the data processor. Data processor is the one who is processing the personal data on behalf of data fiduciary. So it's part of data fiduciary, and the framework, that the rules and regulations that are applicable to data fiduciary to the extent is applicable, but ultimately the primary responsibility is of the data fiduciary in the overall act. Significant data fiduciary is the term that is there, but again, this has to be further defined, which what we understand is the one data fiduciary who is actually processing the sensitive personal data, or the volume is such that it is considered as a significant data fiduciary. Next is the data protection officer. The data protection officer is basically a internal body, internal governance body, who actually oversee that the data should be processed as per the rules and regulations. If there is any breach, that should be notified to the authorities. So that's the role of, and in case there is a breach, the data principal can reach out to the data protection officer for information. So that's the internal governing body set up under the Act and the rules. Then another is a data protection board, who is actually overlooking the overall framework of this Act and the rules, who will provide, who has already laid down what can be done, what cannot be done. If there is a breach, it should be informed. Like consent manager required to be obtained its registration from the data protection board. He has the authority to provide, to decide whether the consent manager should get the registration or not, basis, the various eligibility criteria provided under the rules and their inquiry. And then there is another body which is not mentioned here, is the appellate tribunal. If someone is not satisfied with the decision of the data protection board, they can reach out to the appellate tribunal, and that is basically a TD set, which is the appellate tribunal here. And then obviously the central government, which has the power to provide the rules and regulations to further regulate the provisions under the Act. So I'll just give you a bird eye view of overall rules, and then we can discuss in detail the more relevant concepts and the questions that you may have. The first one is the notice for consent-based processing. So under the Act, it was required by the data fiduciary to send a notice to the data principal to seek its consent for processing the personal data. Now, what all is required, how it is to be structured, that is further detailed in the rules. It should be in the plain and simple language, easy to understand by the data principal. So when we say easy to understand, it itself gives a connotation that if a person is from a remote village, may not understand the English, there is a local language, then in that case, notice should be in such language which is understood by that individual. So that in case, when it's not only the English, the various language should be provided, person should be provided to opt in, to understand, to opt the various other language, to understand it, and then allow or provide its consent to the data fiduciary. And other the important point is that what all data to be collected, that should be specifically mentioned. What purpose it will serve, like if you are collecting a PAN, then what is the purpose of collecting a PAN? How it will be used for providing you the goods and services. So that should specifically be mentioned. Say you are collecting a data, your PAN of an individual for processing the tax on the, so that should be mentioned. This is for the purpose of maybe the KYC or maybe for the purpose of deducting tax. So all these should be itemized on the notice itself. Next one is the processing personal data of a children or person with disabilities. Now, this was there in the act that for processing data of a child, its parental consent is important. Now, it's a verifiable parental consent that is required to be obtained by the data fiduciary. How that can be obtained? So there are various ways of doing that. It may be the Aadhaar KYC, or it may be through OTP, it may be through video verification. Person has to ensure that, data fiduciary has to ensure that it's an adult who is providing a consent on behalf of a child to process its data. In case of person with disability, its legal guardian approval or consent is required to process the personal data. And that legal guardian, now what is required to be verified by the data fiduciary, that legal guardian is the one who is actually appointed as a legal guardian as per the court or the local authority. So these are the things that to be verified by the data fiduciary while processing personal data of a child. Next one is the intimation of personal data breaches. So in case there is any breach, then data fiduciary is required to report that breach to the data principal as well as to the board, Data Protection Board of India. So both these things to happen immediately. There is no timeline defined for this. What is written is without delay. So what all need to be reported here in the first level information, what type of breach has happened, what extent of breach has happened, where it has happened, location where it has happened. So all these things need to be informed to the data principal as well as to the board. Now, within 72 hours, data fiduciary is required to provide a detailed report. With detailed report means what all you have already reported, a detailed version of that, which includes along with the other information, who has caused the breach. Was it something internal or external factor? Or what remedial measures have taken to ensure that it should not occur again? And the report that was submitted or that was provided to the data principal on account of the breach should also be sent to the data protection board. So this is again something that in case of breach, there is a clear set rules how that to be notified to the Data Protection Board of India and the data principal. Next one is the reasonable security safeguards. This is again was there that the data fiduciary has to ensure that it has reasonable security safeguards in place while processing the personal data of the data principal. Now, reasonable security safeguards includes various things. One is that how to ensure that the data is secure. This can be through encryption, through masking, through obfuscation. So basically keeping the data under lock and key, and no one should get the access unless that person has a permission to access. There is a need or there is a requirement to access such data. So there should be appropriate access control in place, appropriate measures to secure the data in place, other technical and organizational measures to monitor and enforce security. So again, it is important that there should be a digital way to check the access. That can be done through the logs also, who has access to data. That further helps in understanding if there was any unauthorized access to the data. So all these things should be there in the system, which helps the organization or any external institute to investigate if there's any breach. So they have given a very clear or detailed, layout how this reasonable security safeguard should work. Personal data retention period for data fiduciary. So here in what is expected that the data fiduciary, specifically the e-commerce entity having not less than 2 crores registered users, online gaming intermediaries having more than 50 lakh registered users, and social media intermediary having less than 2 crores registered users should delete the data after 3 years in case the data principal does not approach these data fiduciaries for performance of the specified purpose, in case there is or sorry for specified purpose, or if there is no such period, like from the date of commencement of these rules, the 3 years may end from the date, if from the date of commencement of these rules. There are 2 points, sorry. One is that there is the data principal is not approaching the data fiduciary for deletion for a period of 3 years, and that 3 years may be from the date of commencement of these. If today the date these rules are enacted, and for next 3 years person has not approached, then this can be deleted. If the person has approached today, the commencement has happened, and the person has approached tomorrow, but then thereafter the 3 years not approached, then again the data should be deleted. However, before deleting the data fiduciary is required to give a 48 hours notice to the data fiduciary, an opportunity to confirm that want to retain the information in order to get the specific services, good and services. If does not hear back from the fiduciary, then he has from the principal, then he has the right to delete the data. Cross-border transfer restrictions. So there are two parts. One is for the central government can specify the specific requirement for transferring the data outside the territory of India. So that this is the provision that they have added in the rules. For SGFs, they have said that the central government may restrict certain set of personal data to be transferred outside the territory of India. So set of personal data is yet to be clarified, what type of personal data and what requirements to be met by the data fiduciary while transferring the data. Both things are still gray and need to be clarified by the government. Next is the additional obligation for SGFs. SGFs is the significant data fiduciary. So significant data fiduciary is required to conduct that impact assessment and the audit. Now, the significant observations from these impact assessment and audit is required to be reported to the board. These are the additional requirements. Apart from that, they are required to ensure that algorithmic software that is deployed to process the data should be reviewed on an annual basis. Exemption for processing personal data for risk. So this exemption is basically for two classes. One, for processing of child data, and for research and archiving statistical purposes. So for second purpose, research and other purposes, this is a complete exemption from the provisions of the Act. However, processing of child data, there is a limited, exemption. What exemption? That under the Act, it was required that person should obtain the consent of the parent for processing the child data, and that data should not be used for behavior tracking. Now here, what they have done, that in case the data is used to process for providing some medical, treatment, or it is processed by some healthcare professional, in that case, consent is not required, as well as behavioral tracking is also possible, but only for the purpose of providing the treatment. Similarly, for educational institution, behavioral tracking is possible, provided it is only for specific limited purpose. When we say educational institution, it includes crèche and healthcare facility, daycare facility, and the transportation system provided by such institutions. So again, the limited tracking of behavior is allowed. It's not that the complete full behavioral tracking is allowed or processing is allowed. Calls for information, and here the central government may call the board, the intermediary or data fiduciary to provide the necessary personal data for the purpose of processing it for the purpose of national security, sovereignty, integrity of India. So there is so this is the law, but what we understand is that this will not supersede or the rule that was framed under Puttaswamy privacy ruling will apply, which says that privacy is the fundamental right and state action can only interfere in that privacy right if if it satisfies the triple test. One is the test of necessity, second, legality, and third, proportionality. So we understand that legality, obviously, when state will ask for the information, there should be some, purpose, and specific authorization is there under the law. Necessity, that's already mentioned, it is for the security, sovereignty, and integrity of India. Proportionality is something that has to be determined at the time of collection or seeking such information by the central government. So that's all about the key provisions of data protection, the draft Digital Personal Data Protection Rules 2025.
And Pooja, I'll also invite you to share your views on this. There's a couple of pointers here. We are talking about specifically when it comes to consent from parents, guardians in case of a child or people with disability. Now, it sounds very easy, but also you need to establish whether it's a real guardian or not, because we are talking about guardian as per who's specified by the or authorized by the court or by the law. Now, how practical and what kind of a challenges you foresee in actually implementing these kind of regulations or these expectations? Because I'm talking about specifically, let's say, edtech industry. Your software you will be definitely used by the kids. Now their parents will have to give a consent, and sometimes there are a lot of these things where you may which will be free, something which is paid. Okay, definitely it's easier because you are paying, the parents are paying, it becomes easier to collect the data. How do you see the challenges? What kind of a challenges you see, and what is the practical approach which you are suggesting also?
Neera, would you like to take it first and then I'll go on?
Sure, Pooja. So here the point is, and the rules, what is expected from the data fiduciary, that they just need to verify that the parent who is providing the consent is an adult. It is not required to verify that he is the parent of that child. However, in the act itself, there is a requirement, there is a duty and obligation of the data principal, where it is required that he cannot impersonate anyone. So there, and the data provided by him, is it correct? And all those things are already there in the act. From that perspective, the obligation is on the data principal.
Which is the parent in this case?
Yes.
Okay.
So Jayant very, very rightly pointed out, and Neera, thank you for putting it out so succinctly. So frankly speaking, establishing a parent-child relationship goes way beyond the construct of this law, because there are going to be so many use cases where, in terms of where a parent is not available because of, say, some physical, because they're not in the physical proximity, or in terms of an unfortunate case where there is an orphan case involved, or where there is an estrangement, where the child is entrusted into the care of a guardian, so on and so forth. So establishing a parent-child relationship as a first step of seeking consent, I think that goes beyond the ambit of the law. So what they have very clearly stated in a lot of the consultations that they have done is that, like Neera said, first of all, a certain, or through a self-declaration, especially if this person or if the data principal who is coming onto your platform is a child, so you should either have a self-certification mechanism or an age-gating mechanism to determine that you as a data fiduciary have done your due diligence when you are accepting or recognizing this data principal either as an adult or as a child. Right, so that you need to have it documented very well in your in your controls. So that can happen in two ways: either a self-certification or a self-authorization, or through an age-gating mechanism. The second part now comes is the parental consent. So once you identify that this is a child or a minor or a person under the age of 18, right, then it is required that a consent is sought from a person who is 18 years or above, so an adult. And the fact that this person is above 18 years or above needs to be established beyond doubt. So you need to then verify the age of the parent slash guardian who is giving the consent on behalf of this minor. So as long as you have processes and you have documented what your mechanisms are, you should be able to demonstrate your intent to comply with these regulations. And like I always say, compliance is always that you can never attain 100% compliance, right? Because it's always an evolution, it's a journey. So what you need to then do is, number one, demonstrate a clear intent to comply with the law. And that is not just intent in terms of documentation, but following through that documentation with proper controls and implementations, right? And then you need to kind of maintain the proof of compliance or the evidences that come up with it, that you, whilst you intended to follow, you also had the resources to follow through, right? So if you have a very nice policy that says, oh, we will do age gating, we will do so on and so forth, but your technology is not, or your solution or your product is not supporting those internal compliances that you have decided for yourself, right? So therefore, then following through with what is written in the policy and having a demonstrable evidence is what will kind of take you through the finish line.
Great. I think thank you so much. This was quite insightful. And next question on the say, previous slide. So Neil, they mentioned about informing in case of a data breach, personal data breach, it should be informed immediately. Now we're talking about informing the board to the board immediately,
Yes,
right?
both.
And there is
Both.
and there is a certain expectation also that in case of a data breach, within 6 hours you are supposed to inform. Now, this will be two different expectation, one to certain in case of a data breach, and one to the data protection to the board also. Is that understanding correct?
Yeah.
Yes. Yeah. Yeah, please go ahead, Vijay.
Yes,
Okay.
Neera, please. Okay, thank you. Yes, like you rightly said, there are dual reporting mechanisms that or reporting requirements that have been highlighted both in the law and the act as well, rules as well. One is as soon as possible, as soon as you come to know of a breach, right? It's not when the breach has occurred, but one you come to know of the breach, right? So the breach may have occurred, especially in a typical cybersecurity scenario. The threat actor might have been sitting in your systems for say X hours or X days, right? And it is only uncovered at a specific period of time. So the clock starts from when you understood or you identified it as a breach or an incident, and then you need to do it immediately. Next thing is you also need to inform the data principals, the affected data principals. Now, whether there has been a timeline given of what is as soon as possible or when to respond to an affected data principal, to my reading, and I could be but there is no timeline that has been defined yet. The 6-hour timeline is to certain, which is a different kind of a regulation or a legislation that also requires you to report any cyber security breach. Now, whether cybersecurity breach includes a personal data breach and overlap and all, yes, that there is a different conversation that can happen over there. But yes, the other timeline that is very strict and has been called out is the 72-hour follow-on reporting that you need to do once the initial reporting has happened. So say, for example, I report today at 10 a.m. that I have suffered an incident, which I got to know, say, at 8 a.m. or a 7 a.m. or maybe like, a previous night, 2 or a 3 a.m., right? So I took that much time to kind of investigate. I understand that, yes, this is actually a breach that now needs to be reported. I then go ahead and do the reporting at 10 a.m. My clock starts for the 72 hours from that 10 a.m. reporting, in which I have to then come back with certain additional details, such as a more in-depth of who are the impacted data principals, what is the data that was breached, what is the risk involved, if you can identify who is the perpetrator of the breach, so on and so forth, right? So all of that is listed in the rules. So that 72 hours is what that comes in over there.
Understood. But it doesn't talk about within 72 hours, you have to also do an RCA, those kind of expectations. Now that's just a follow-up reporting.
Follow-up detail, yes. So a detailed RC, obviously, so again, it's like a Pandora's box, right? The more you dig, the more information you will get. So for 72 hours, you are required to get substantial information about the breach. How did it occur? Where did it occur? What is the impact? How many people are going to get, what data principal rights are going to get impacted, so on and so forth. Also, what measures should the data principals take in order to prevent a breach, prevent further harm, right? Or mitigate the consequences of the breach, so on and so forth. So all of those are kind of identified, and within 72 hours, you're expected to kind of work on all of that. And then a more technical RCA, which is more to do with, with a more thorough mitigation and all, that can be brought in follow on. But then depending on the severity of the breach, the Data Protection Board can then give you saying that, okay, once you've done the 72-hour reporting, then how does it follow through? Then what is the investigation? Does it turn into a typical investigation with any authority like it does, right? For example, they can then come back with follow-on questions and then so on and so forth. So then that will follow, that will become that will take a life of its own. But that 72-hour deadline is what is, yeah. Yes, Neera.
Just to add here that there is a slight flexibility. If you feel that 72 hours is not sufficient to provide the complete detail list that is there in the rule, then you can request the board to provide some extension, and board may consider that. So that part is also there.
Great. I think this is because yes, sometimes 72 hours may not be enough to do a proper RCA.
Correct.
Okay.
Correct. Consent managers, very, very controversial as well as interesting at the same time, because I think the DPDP is one of the first laws or is unique in that way to introduce a different stakeholder like a consent manager. You don't see something like this in any other privacy legislation across the board. So what is this? What is this animal, if I may call it that? So number one, a consent manager is a separate juristic entity. It will not be somebody which is like, so a bank cannot have another department acting as a consent manager, right? I am just kind of oversimplifying it a little bit, but a consent manager necessarily has to be a separate entity, a separate organization, independent of the data fiduciary, right? So the board of the consent manager, the people who run this organization, have to have a degree of independence. And the reason why this is required is because the primary responsibility of a consent manager lies towards the data principal, right? So they are accountable for ensuring that the rights of the data principal in terms of access, in terms of consent, in terms of other nuances within this law are upheld through this consent manager, right? So a data principal can request another data fiduciary, say a bank or a school or a gaming company, to provide them access to their requests, to them provide access to their data, or to provide access to or to kind of consent or revoke consent which they had previously given to these data fiduciaries through this consent manager. So therefore, consent managers' independence is very, very crucial. In addition to that, consent managers are required to then have certain obligations on themselves as well, in addition to this independence. That is, they need to be data blind. They cannot see what data is being transferred between, say, two fiduciaries. So a very simple example of this, and simple in terms of me trying to explain this in that way, is, say, for example, I, as a customer, want to transfer some data that I have given to bank A to bank B because I'm availing a loan from bank B, right? And I have a consent manager saying that go and please. So bank A has the consent to this data of mine. Please go ahead and tell bank A to transfer the data to bank B, and please transfer this consent to bank B, right? So therefore, then this consent manager will then take this request that I have made to them, make this request to bank A, and ensure that the bank A is transferring the data to bank B. So that's kind of a bridge that the consent manager will then be acting as, wherein because the consent is transferring, the data that is transferring underneath that consent is also kind of moving, but the consent manager should not see what data is moving. So the consent is to say transfer bank account statement or PAN or Aadhaar. But what is the PAN? What is the Aadhaar? That the consent manager should not be seeing, right? And that's where the interoperability of consent also comes into picture. I know it's getting a little technical, but stay with me on this. So we are all aware of the account aggregator framework, right? So that account aggregator framework is very well established because we basically are allowing somebody to kind of look at what the data is, what account statements are being held in bank A and then transfer them to bank B. But they're able to do that because all banks hold the data in a similar fashion, right? They all have a standardized way of holding that data. So similarly, a consent manager will have to have an interoperable platform in which the personal data which is being held by bank A can be transferred to bank B. Yeah. So that's a little bit on the consent manager platform. There are some obligations that says that it cannot subcontract its obligations to third parties. So a consent manager cannot have another consent manager or cannot subcontract it further. Platform must disclose specific company details on its application or website. So you cannot have. So the independence is kind of given very. It's given extreme importance here. Transparency has to be maintained. There has to be a robust audit mechanism because here the data principal is trusting them with, to exercise rights on their behalf. So ensuring that all rights or all requests made by data principals are actually flowing through and are being serviced, so on and so forth. So that audit trail has to be kind of incorporated. And in order to ensure all of this, there are certain financial parameters, there are certain technical and operational parameters that consent managers will then have to go through. One thing that is going to be very true that consent managers are going to be technical organizations. These are going to be either platform service providers or some sort of a digital service providers who are going to provide this interoperability of consent. Any burning questions, or we can take them at the end and move on to the next slide.
Just a couple of quick ones. No, this is a very, very interesting concept because, today there is no standard way of taking data. Anybody is asking any data, I can, starting from the name itself, somebody may. And again, we are living in a country like India where, I'm going to write my name in multiple ways also. Somebody says name, surname, and somebody says, what kind of a practical challenges, one, we are seeing here from a organization standpoint? Because if I am a data fiduciary, I have to, have a consent manager. I have to start preparing for how I'm collecting my data or I'm even storing my data, right?
Correct.
Right. And second, are there any organizations who exist today who are the consent manager or do they need to be, governed, registered with some, with the board, with the government?
Yeah.
So can you throw some light on this?
Sure. So I'll answer the second question first because it's a little shorter. So yes, a consent manager needs to be registered with the Data Protection Board. They are a licensed entity. So they will have to kind of comply with certain requirements of the Data Protection Board, some of which are mentioned in the rules, some of which may just come out once the Data Protection Board opens up the licensing portal and application form, so on and so forth, right? So yes, they will be licensed entities who are going to be separate. Coming to the first question now, what are the challenges? The challenges are way too many. I mean, for those of us who are also in the consent management space, right? For us also, the challenges are, the first thing is, whilst they claim it to be interoperable, there is no standardization of personal data, right? Interoperability can be achieved only if there is standardization. Today, account aggregator framework, like I mentioned, is possible because there is a standard way of maintaining a bank account statement. Simply, you go to bank A, bank B, private, public, cooperative, scheduled, any bank you go to, a bank account statement will look in the same way, right? So that's a standardization. So that's why, because it is standardized, number one, and because it is digitized, right? The entire banking system today is on core banking or is digitized to at least to a 90-95% extent, and hence the interoperability works because everybody is on the same platform in the same with the same set of data. Now, how will we kind of achieve this when it comes to personal data, where the definition of personal data itself is is diverse? And if I open into what is personal data, I think we will have to have a separate seminar only on that, because there are certain people who believe that everything is personal data, and then there are certain who believe that only, say, a unique identifier is personal data. There are debates on whether browsing history and preferences, right, of tracking of how I'm using a particular website or application, whether that qualifies as personal data, right? So there are schools of thought over there, and when you have such diverse schools of thought, or even the fact that you have such a diverse subjective thing to quantify then and then bring onto a standardized platform, that is going to be a biggest challenge. So interoperability of consent managers, because if it is not interoperable, consent managers will lose a lot of their charm or their usability, right? Because here we're trying to make the lives of the data principals easy. So then you will have the potential of saying ki, then it could become a case where the maximum number of data fiduciaries signed up on a particular platform, only that platform will run. So then you will have the implications of MRTP practices and it becoming like a siloed thing coming into picture. So how they operationalize the consent management framework and how they bring in the interoperability standardization, that to my mind is very, very crucial. And unfortunately, luckily, unluckily, nobody has answers to that yet. I mean, this is one of the things that was raised through the consultations across the board to MeTi, to all the regulators who had asked for their respective sectors to kind of come up with answers. So let's see what comes up.
Is there any timeline given in the rules right now, which talks about, by when the consent manager should be in place or?
Good question. Brilliant question. So it's funny because the rules say that a consent manager license will be issued by the Data Protection Board. And for the license to be issued, the board needs to be brought into picture first, right? So once the board gets constituted and they come up with the form and the license, only then the consent managers will be brought in. Now, when will the Data Protection Board be formulated? Very interesting, because the rules notify that the sections for the Data Protection Board will come into effect the date the rules are published. And the enforcement ones is where they will give a 2-year time period or an 18-month time period, whatever the rumors are going, a later date for the data fiduciaries to become compliant with the law. So best case scenario, assuming that the rules get notified, example, 1st of April, right? Or say 1st of May, Data Protection Board should be up and running within, like, if not on the 1st of May, then as soon as possible post the rules being notified, right? Because, and Neeta, please correct me, but to my reading, I've not seen anywhere where it says that the board will become functional at so and so date. I think they have, yeah. So therefore, then it's quite, so you can look at a data, and then once the board comes into picture and then the licensing comes in, the adjudication of a license, the time taken to adjudicate whether the license should be provided to this person or not, that will also come into picture. So my 2 cents about this is that organizations should have their own consent management practices, either through tool, and definitely through tool, because otherwise revocation is difficult. So they should have their game plan or their roadmap ready. They should look at how they're going to internally govern their consents. Let the consent manager come out as and when the board comes in. And then, because you already have a tool solution, the 2 solutions can then talk to each other. And if I may, just look at a tool solution that is on the electronic consent framework, or that gives you that interoperability function, because then your integration with your consent managers will become so much more easier later.
So Pooja, you spoke of a very interesting point, Now, you said,
Mm,
forget about interoperability. Within organization, I have multiple applications which are collecting my
mm,
the data or which of my users. Now,
mm.
implementing a simple SSO in an organization for running their for their own employees is a mammoth
Yeah.
task.
Yes.
Here we are talking about your client data. No, I could be an Amazon, and I still might have only a few, a lakh employee. But I am an Amazon, I'll have few crore users. Now, if I
Mhm,
have two different products, both taking users' data, uh,
mm.
how is industry even thinking about managing it internally? Forget about with the consent manager.
Brilliant. So the answer to this is a little is a techno legal, techno operational answer, but
Hmm,
unfortunately there is a technical aspect to it. So if you
hmm,
want to make your consent, if you want to ensure that all departments are processing data as per the consent of the individual, you will need to make sure that all the applications are talking either to each other or to a centrally managed system that is telling them that they have the consent to do this activity or not. And I'm oversimplifying here. So say for example, I let me take it up with a journey, right? I have onboarded a customer. I need 3 or 4 data elements to provide XYZ services to them. I need to know their name, I need to know their email ID, I need to know their phone number, and I need to know their PAN or Aadhaar or something because it's a KYC requirement, right? So with these 4 data elements, I am going to be using them for different purposes, right? I may use the name to communicate with them when I'm writing to them. So, hi Pooja, right? I may use the email ID to communicate to them for whatever services that they have availed from me. So just service related updates. So if say, for example, if it's an order that they have placed with me, or if they have placed something like a service that they are going to avail from me, like a cleaning service or a e-commerce service, so on and so forth. The second thing I could be using the email ID for is promotional messages. So I want to tell Pooja that I'm going to be launching a new product, there is a sale going on, so on and so forth. So I want to use the email ID to communicate with her. The third thing is I could also be using that email ID, and the similar analogy goes for a phone number as well, is to train an AI model, right? To
hmm.
kind of say that this phone number or this email ID I want to be using for some sort of a campaign that I'll be running, or some sort of a promotional event that I'm going through, and I want to kind of have these kind of IDs as my target audience. So all of these 4 purposes are being done by 4 different systems, right? But all of
Hmm.
them are residing in a central system, right? Like an MDM, or they are residing in a central database and all. So when these respective API applications through APIs can talk to the central system, where your consent is also kind of stored, or saying that, hi system A, I need to extract this phone number for sending a targeted email or a targeted message, right? Now this MDM can then speak to your consent manager, management system, not the consent managing extended entity, but your consent management system, which will say, did Pooja really give consent, yes or no, for her phone number to be used for a marketing material, right? To receive marketing material. And if the answer comes back yes, you can go ahead and do that. But if the answer comes back no, then you already have an audit trail established that you did not have consent to send marketing material. So please do not go
Hmm.
ahead and process it, right? So for your systems to talk to each other, you will need some system that will say that yes, this is where the consent is residing. It could be, so the consent manager usually talks to consent management system, or consent governance system, usually in good scenarios talks to an MDM to then kind of manage this centrally. In case you do not, MDM is a master data management system, yeah. And if you do not have one, then you can have all of these applications individually talk to the consent governance platform. They can query the consent governance platform through APIs. The query will be responded, and then accordingly they can go ahead and process data.
Pooja,
I hope I'm not lost.
no, I, no, I must really appreciate the way, you tried and simplify this whole thing. Uh, but a very honest question to you. Have you come across any organization who has attempted this successfully so far?
Um, our clients are doing that. So currently,
Okay.
the clients that we are working with,
Hmm.
it's a private bank. So I don't want to do this plug or make it sound like a plug, but IDFI is working with Axis Bank at the moment, and kind of helping them become DPDP compliant and look at their consent governance. There are some loan service providers with whom we are working, and we are kind of bringing it in. So what I'm trying to say over here is your consent governance platform, right, should be agile enough so that it can speak to either an MDM, or it should, or it
Hmm.
or all of your individual applications. And just a disclaimer, I am not a technical person, I'm a lawyer, right? And after working with Identify, if I can understand that this is not really rocket science, then I'm sure that your in-house developers or your in-house technical teams will be able to pick it up a lot faster than I'm. Yeah. So
Okay.
it looks complicated, I agree, but trust me, with the right skill sets and the right minds, it really is not. And it's a
No, so
and the kind of solutions that are there are easier to implement than said. Yeah.
So see, I don't think anything is today in the technology world is rocket science, but the real challenge, what I see, and Neera, I may also want to hear your thoughts on that. Uh, See, there are a lot of businesses which operate at a very minimalistic margins.
Hmm.
Now, if you have to implement such thing, such controls or such practices, I would say, controls, such practices you have to implement, it suddenly increases a lot of your cost. Why in terms of bringing the expertise, the technology, and sometimes, may make the entire thing unviable for the businesses also. You know, your
Uh,
thoughts.
so there are two parts actually.
Mhm.
One is the mindset. So when we say
Mm,
that we have to be compliant with the whole structure, the framework that has been put in place. So we have to start thinking from now if it's a startup or it's a SME, because this is going to be a competitive edge. It will definitely give a competitive edge to them. So it may be an investment. It should not be considered as a cost. First thing. Second part, I would say that there are still, the exemptions that are available under the law for SMEs and, startups. So we need to see what exemptions they will get. But I would still suggest that those who are actually handling this personal data, they should start working on, implementing the framework to ensure that how this can be done through, privacy by design. If they design it in a way that at a later stage, they design their technology, they use the technology to design the, structures in such a way that it will not be a burden, it will be an automatic thing, or that may, and that ease that solve the complete problem. So it all depends how you actually look at it.
yeah, great.
Uh,
But yeah, it's going to be interesting. I think consent manager, the complete principle of consent manager, and how you really establish it within your internal applications, which are which are your client facing, your user facing. Um, great, great insights for me.
yeah. So this is a little bit about the implementation strategies, and I think what we've discussed at length. So whilst consent governance is one bucket of compliance, if I may call it that, the DPDP requires you to do some additional activities as well, depending on whether you are a fiduciary or a significant data fiduciary. But irrespective, there are certain obligations that you have to meet, and which will get audited in a yearly fashion through the privacy audits. Uh, as the law comes into force. So, what are those activities that you can do to ensure that you are demonstrating compliance with the DPDPA? So, number one is do what you document and document what you do, right? In terms of personal data. And full credit goes to ISO, because this is one of their ethos and their tenets. That is, whatever it is. So, whatever you want to first do with the personal data that you're collecting, first step is think, why do you need this personal data? And the minute you have an answer to that, make sure that you have a document or a place where you are writing that answer down. So that becomes the first principle of data privacy, which is purpose limitation. So if I am collecting a personal data element, why am I collecting it? So that's your purpose, right? So have processes that basically talk about the what, the why, and the how of your data processing. What it means, what personal data you're collecting. Why means why are you collecting, which is basically your purpose limitation, and how are you collecting it. So that's basically your operational bit of it, right? And that's where your storage limitation and all the other principles, the security of the personal data, the retention, storage limitation, all of those get into picture. So basically have processes in place to kind of do the documentation about the what, the how, and the why. The next step that you need to do is to look at processes that can explain the what, the how, and the why to a data principal. So that's basically your data principal rights management. So have processes where a data principal can come to you and request what data they hold about you. If they have a grievance about how you're processing their data, they can raise that grievance. If they have an amendment request to change the data that they hold about that we hold about them, or if they want the data to be erased. Now, erasure is again another point of great discussion and interest here, because a data principal may expect you to erase the data as soon as their relationship with you ends. Like, I would love for Amazon to delete all of my browsing history as soon as I finished a purchase, because I don't want them to then profile me and keep showing me the same kind of products. But they are mandated and required to keep that data, because there is a regulatory requirement in place, or like some of the people are commenting, because that's how the internal systems are built, because they may have some settlements that have to happen within, say, next 3 months, or 3 days or 3 hours, if not that. So there are certain overriding extremely important necessary reasons why you may need to hold on to that data. So make sure that you have processes that document the reason why you're holding on to that data. And then once that purpose is met, or once that timeline for that purpose is met, have processes to trigger alerts saying that this purpose is now met. So would you like to go ahead and delete the data, or do you need to extend the retention, say because there is a legal hold or there is a potential dispute for which you will want to kind of continue holding on to data. So make sure that you're documenting all of this, and then as and when all the ifs and buts and triggers are kind of met, you actually go ahead and either anonymize the data, that is, you make it not personal or non-personal, or then you go ahead and erase it from your systems completely, so that you can then say that you have erased the data as per the request or as per the legal mandate. So have processes around erasure, have processes around documenting what are your reasonable security measures. So we all have, so all our organizations will have implemented, like Jen said, an SSO at some level. So why is a single sign-on so important? Because that is how they manage who can access their systems, right? So it's a kind of a good technical and organizational measure to have, to document who and why is accessing your systems. So document that as a part of your security measures, as a part of your technical and organizational measures. And have technologies, that is the second bit of it. Have technologies who can make your life easier in doing all of this documentation. Hundreds of customers, lakhs of customers, hundreds of systems to manage, so on and so forth. Doing that on an Excel spreadsheet is difficult. So have technologies that kind of do that. And lastly is the bit on audit. Have robust audit practices, L1, L2, L3, kind of audit mechanisms that help you kind of raise the right alerts or the right risks at the right time, so that those can be mitigated and rectified, and you don't have to wait for the annual privacy audit to kind of highlight certain challenges that you're facing. Yep. Any questions here, or we can move to the next slide, I think.
Just one perspective I want to get from you on here. Because we spoke about the need of a data component, right? Sorry, you used the terminology specific for that. So today we have a lot of legacy applications where we have not used our, and I said, I don't blame, because we never were focused about how much is important data for me. right?
Hmm.
So and we are randomly collecting a lot of data which we may not even require, and we've already collected and
Correct.
stored. We have stored it. How um, how should the organization be, looking forward for it? Because till today it was not so important, but today the risk is much more in my system.
Correct.
Do I
Correct.
if I don't need the information which is stored, stored, because if somewhere uh, if I ask for one additional data component from a PI, it may move to a STPI,
Hmm.
sensitive personal information also. Uh,
Hmm. Hmm.
so what is the practical approach, and you are suggesting to the organization here?
Very, very valid and very operational also. So there are two reasons why you need to know what data you hold about the data principles, or what are the legacy data that you hold. Number one, because you are required to present a notice to your existing data principles, or to your existing customers once the law becomes applicable. So one is the new
Hmm.
customer who is going to come to your platform. Unko you can give a consent. You when they start the journey, you show them the consent and you take their consent. But what of the people who are already your customers, right? So you
Hmm.
then need to know what notice to show to them, because that is another specific requirement under the law, that you need to show them the notice of processing done, right? So that is what you need to show them. So for that, you need to know what data you hold about them. So that is why you need to have the data discovery exercise. And the second thing is, even for a new customer, right, you need to know where this data is going to go and ultimately reside. And it will ultimately reside in one of these legacy systems, so that you can then go ahead and tell them when you are processing their access requests, or their correction requests, or erasure requests, you will know which systems to query, get the data out, and then process those requests. So these are two very compelling cases why you need to know where your data is residing. And how do you do that? Two answers again here. One is you can take the automated route of running a data discovery scan. There are quite a few service providers in the market who will kind of help you design your data discovery exercise, who will come and do your scanning on your assets, maybe on your endpoints like your laptops and desktops, and hardware like your endpoint servers, and so on and so forth, and then kind of come up with a very nice map, or a report that says you have so many types of data which is residing in so and so location, so on and so forth. Or alternately, if your footprint is not that big, so a smaller organization which has maybe one or two databases, right? You can also try and attempt this discovery manually by talking to each application owner, if available, and kind of mapping it out and saying that these are the personal data that this application holds. This is the database. This is the purpose for which it is holding. So these are the two approaches you can take.
Thank you. This is
Yeah.
great insights. Yeah. Okay. So let me pitch in with this particular slide. Now, they're very interesting, and I think there were a couple of follow-up questions on on the slide which Nita started with. What kind of industries it is going to impact big time? I think we received multiple queries talking about whether it's going to impact an NBFC industry, or a manufacturing company, or a different kind of an industry. Now, uh, I think first of all we need to understand it is possibly going to impact everyone, because somewhere or the other every industry is today storing the personal information. Now, it could be your consumer, because the first thing goes, and we mentioned initially that the BFSI sector, the banking, financial services, insurances, or mutual funds, they are storing a lot of your data. You have e-commerce platforms storing a lot of your data. You have telecommunications, companies who are storing a lot of your data. These are the one who would get impacted big time. But it does not stop with to these industries only. It goes to everyone possibly. Healthcare again, I would say it goes to everyone. Even if you are a manufacturing client, you're storing a lot of personal information. It could be if you're if even if you're not doing retail selling, even if you're not don't have any e-commerce platform, you may still have hundreds and thousands of employees. To have those hundreds and thousands of employees, you may have scanned lakhs of employee data. Okay. And during this interview process, during this screening process, And it's a habit of of us that we keep storing what we get. Okay, as a part of our a hiring process, we collect interview resumes. Even if we are not hiring today, we collect resume, we store them, and we ask them a lot of information. I think everybody gets impacted some way or the other. I just gave one example. It's not the only that's the only example. There are multiple cases. Your vendors data, your vendors employee data, even if outsourced employees and all, you have multiple touch points. First, we need to start understanding what are those touch points for us. Second, we need to also understand, see, data protection is or DPDP is going to be I would say one of the biggest implementation of any new regulation in India. We thought GST was was the biggest. I think GST, they were only 1% employee in the organization, or maybe 0.5 or 0.22% employees in the organization who were actually concerned about GST, who really were breaking their heads on knowing GST. This is going to be impacting everyone, possibly. You are a large bank. So I was talking to somebody. He's the company is into it's in a banking domain. They have around 5,000 employees on roll, around 30,000 employees off roll. 30,000 are the ones who are actually dealing with the data of their clients, the users, their loan holders, their credit card holders, and they all need to be trained on how to collect data. They all need to be trained how to what to collect, what not to collect. It's not going to be only a CFO or IT head or a legal head who needs to know this. Building a policy is very good, but building a policy does not percolate the information down to the end user who has to really collect that information. Imagine I'm a bank. I have a DSA who's selling my loans on my behalf. The DSA has an employee who is not even aware of what to collect, what to ask, what not to ask. Sir, send me all your data on my WhatsApp. Okay, and then here's all your data, and we are happily sending all my data, right? As a consumer, we are not actually so aware what to do, or what to give, what not to give. Tomorrow, any breach happens, will the employee of the DSA, will he be sued, or the DSA be sued, or the bank be sued? Who is responsible? In this case, it's the bank who will be responsible. The bank will be party to it. Now, you have to have a control on the entire chain. One, by building your technology, so that you can say there is a right way of collecting, which is an established practice. The information and the documentation required, which is a more secure way of collecting that information. You have to also establish that we have given enough trainings to that employee who was supposed to collect that information, and there was some kind of an indemnities. There was some kind also sort some kind of test also been done. I think it is going to create a very mammoth, exercise, and it's not going to be one-time exercise. It's continuous. Imagine in a sales, you have a large sales team and thousands of sales people on the ground, on the streets. The attrition is as high as 50% annually, sometimes more than that. So you have thousands of people, and thousands of people are coming and going. So you have to ensure that everybody's aware of it. But that's a big challenge. It's not just about building policies. It's about building training modules, ensuring they are updated, ensuring people are trained well, and you have a full control on the way the data is getting handled. Okay, because smaller guy, and again, I give very practical examples. Today, if I have a 50-seater call center, I can get some business from a bank to sell their credit cards or to do a collection for them, even if I am operating from a residential complex, because I'm giving a very competitive rate, and bank will be happily giving me their data to go and call the person and collect, do a collection on their behalf. or to sell, on their behalf. These are something which are a time bomb, because the penalties are very, very massive. Not just the penalties, I think the reputational risk will be much more massive in this case. Um, this will allow, on a very lighter side, I think this law has a potential to bring consolidation in many industries. So I think we have to be very, very mindful of that particular thing. That's where I would say the impact on the business and organizations. Uh, you know, you have to mature your processes much more than what it is today. And again, awareness has to be at every level. Mira, your thoughts from an industry perspective. How are different leaders? Because after any law comes, so hey, the legal head, you are responsible. I'm not very worried about what is the law. So you have to ensure that everybody is aware, and you have to ensure that company is compliant. How are you seeing, and how's the board seeing, and such uh, changes specifically to this law?
So, Jayant, as you rightly said, irrespective of, in which industry you are, each and every industry is impacted. I saw some question whether B2B will be impacted. Yes, because it is all about the personal information of an individual. In B2B setup also, we collect personal information. So it's going to impact everyone. Now, how as a, as a council, in-house council, how what will be my role for for my board or for my management. So what I see that we really need to give a proper a proper guideline what all are the compliances, and make them understand. We need to create a awareness sensitization, as was rightly highlighted by Pooja. There are two aspects. One is the law and the awareness. Second is the on the flow job, means how this will be done, who will be there should be a team who can take the responsibility of the full-fledged implementation of this whole DPDP framework in the organization, because there is no way we can escape the requirement today or tomorrow. And most of the organizations who are actually operating at a global level are already complying with some or the other data protection law. So it's not that we are not doing anything. Even in today's world also, to the extent we are complying with the SPDI rules, where it says that if you have, if you have got yourself, you have a ISO certification, then reasonable security practices in place, and you can be, safe. You can always say that there is a breach, but we have ISO in place. So obviously the burden of proof is gone, because you don't need to prove anything as long as you can prove that you have sufficient, measures in place. But with this act, it's completely changed. Scenario has changed. So what is required now, that we need to identify in our organization the various points where the personal data is getting collected. It may be the IT department, it may be the sales marketing, it may be the actual in fact, internally also, when we interact with the IT team have lots of personal data information of the individuals that are working in the organization. It's not only HR that has the information. So basically, we need to identify all the specific points where the data is getting collected, personal data is getting collected, and then put the control there. What data is required? Currently, we are collecting everything. Most of the organizations who are not actually complying with the, the global framework, the global laws that are applicable, like GDPR or Australian privacy law or US privacy law, they are not as concerned about the collection and the processing of that personal information. So one part is the collection, where it is being collected, what is the requirement, what is the purpose, whether the purpose specific collection is happening, data minimization is there or not. All these things need to be first evaluated. Then for this, obviously, one person cannot do the job. As you rightly said, Jayant, it's the responsibility of the whole, whole organization. And for that, we need a specific stakeholders from each team. So from that, once the governance setup is there, then we need to finalize or identify whether it can be done internally, that automation, that use of technology to further ensure the protection of the data, whether that can be done internally, or we need to hire an external resource, because many of fintech companies can do it on their own with the help of the legal counsel and the technology experts. But who do not have the expertise inside the house, then obviously they have to depend on the other parties for providing necessary consultancy and the implementation of the framework. So with that, once the protection is provided basically to the data, which includes, the privacy policy, updation of privacy policy, the consent mechanism, data encryption, access controls, automated data retention, deletion rules. So it all means overall framework to ensure that the governance and the controls are in place. Then obviously, as mentioned that by Pooja, that training of the employees and awareness is must to have. Because without awareness, even after having all these in place, as just you have given an example that banking personnel is collecting the information, personal information on WhatsApp. Now, if it continues to happen, then obviously all that control, all that, encryption, privacy policy, consent, nothing will work. So it is important to ensure that the employees are trained to the whole framework, sensitize about the penalty that can be imposed on the company just because of a small lapse on their part. Then we need to establish the incident response, protocols, where if there is a breach, then how this will be escalated to the next level, because there is a requirement to notify if it's just DPDP. But if you're operating in the insurance sector, if you are operating in the banking sector, if you are a listed company, then there is a requirement to notify different authorities about the breach. So that matrix should be there, and everyone is aware of that matrix, because if breach has happened at a ground level, but the person who is required to report that breach should never ever get to know about it, in that case obviously there will be a non-compliance. So again, a whole incident response protocol need to be set up and to be informed at all levels. And again, as you mentioned, that the vendor setup is we have a vendors to whom we outsource the processes for processing of information. There we need to ensure that the similar setup is there, so that they can also ensure the 100% protection and the security to the personal data. How this can be done? There are two ways. First, we should have the relevant clause in the agreements, which provides that in case there is a lapse, they will indemnify the data fiduciary, as there is no provision under the law where processor can be held responsible. It is basically the fiduciary who is responsible for any lapse, even if it is at the end of the processor. So from that perspective, it is important that the agreement should be tightly claused, and necessary provisions are there. And they should have a fear that if there is a breach, then harm will happen. Another point is the audit rights. Fiduciary should have the audit rights to ensure that whatever the protocol is required to ensure the compliance under this framework should be there, and that can be on a periodic basis, that can be audited. For internal factor also, for internal in-house also, the companies are required to conduct audit to ensure that they are following the relevant protocols that they have set up, the relevant guidelines that they are set up, to avoid any non-compliance. That's its high level view, how we can support our organization in actually ensuring the compliance with this law.
Pooja, if you could actually talk about uh, the next phase, because this is very important, and um, government is coming out with the regulations. Is still, I think it's a $1 million question. Nobody knows what is the date. Um, uh, but suddenly it will be implemented and will be expected to know, to get everything done. So how much time it's going to take to us, and what should we do?
Good question. If it is okay, can we? Yes, this is the slide that I was going to
Hmm.
ask you to kind of bring up, because it kind of helps us visualize what the journey will look like. Um, so what I always recommend all of my clients to do is always break down the problem into smaller bite-sized pieces. In this case, let's look at the DPDPA compliances. There are two sets. One is where you are directly, which is a customer facing or a data processor, data principal facing compliance, right? Wherein if you are a B2C, or even if you're a B2B, wherein your data principal is maybe an authorized signatory of your client, right? So what do you need to do so that to a data principal, you are compliant on day one, right? So that is basically making sure that you have your legal basis of processing identified. If the legal basis is consent, then you have a consent governance framework in place, which means number one, identifying what are your points of entry, how are you collecting the data, where are you collecting it from. If you are if it's digital data collection that you are doing, right? So that means there is a digital journey. So where do you want your consent to be brought in so that the individual or the data principal can exercise their rights, say that, yes, I consent to my data being used for A, B, C, D, E purposes. And then you store that consent. So how do you store that consent? Where do you store it? How do you make sure that it is tamper proof, that it is not being, it is accessed in a secured manner, so on and so forth. Then you also look at what are your data principal rights, right? So the next thing that you should, so one thing is consent and the notice that is supposed to be going with that consent. And I'm not going to spend time on what a notice should look like. Neera has done a brilliant job in taking me through that. So consent and notice is one. Then how am I exercising my rights as a data principal? So am I giving them a mechanism? Am I giving them a web form? Am I giving them an email ID that will kind of go ahead and say that, write to us here in case you want to access what data we hold about you, or you want to kind of erase or nominate or raise a grievance, so on and so forth. And then the next bit is, and I think it goes back to the consent and the DPRM, is the revocation bit. So if consent when revoked, right, what will happen to my data? So I should have the right to revoke the consent and also ensure that the downstream of the data fiduciary, that is either through data principals, data processors, or through internal systems also, there is a stop of the further processing of this data once the consent is revoked. So I do that first. I pick this up first because this is very apparent, very visible. On day one, I need to make sure that I'm doing everything I can to service the data principles. The next thing that I can kind of do simultaneously is look at my internal processes and look at the technology solutions that are going to support my internal processes. So making sure that I am securing the data in the best possible manner. If I'm holding extremely sensitive data like Aadhaar, PAN, financial data, biometric data, or I'm dealing with children's data for that matter, right? Then I'm kind of doing it in a secured manner. I'm ensuring that I have access logs enabled. I have database activity management systems involved. I have a TLP involved, so on and so forth, right? So, and I'm consolidating all of these security measures through documentation and ensuring that I can then demonstrate compliance. Then I'm also looking at my risk assessments, my data protection impact assessments or my privacy impact assessments. And if I'm a significant data fiduciary, do I have that audit plan in place, right? So that is my next thing that I will kind of want to look at. And then finally, I will also want to kind of whilst all of this is happening, I will also want to do that the data discovery exercise should be kind of first designed, formulated, and then those scans are being run, or that data flow diagrams or all of those things are coming into picture, and so on and so forth. So your 18 months can be broken down into these 3 phases. And it is not that these phases will go in a chronological manner or one after the other. You can, depending on the size and scale of your operations, pick up the priority one, which is basically whatever you are facing to your data principles first. And whilst you're doing that, you can have another set of resources kind of who work on the data discovery, who work on all of your other internal processes, build them up, bring them in. You build your vendor management process also from a privacy angle. You start identifying who are your third parties, who are kind of going to be impacted through the DPDP Act, because if they suffer a breach, the liability lies on you, right? So whether you have those contracts in place or not. So this becomes priority one, but simultaneously your resources are equally spread out in doing all of these other things. At the end of the first 3 or 6 months, say I'm not saying from the date of enforcement, wherein you will require everything to be in place, but from the date of notification of the rules, saying that the law will become enforceable, say 2027, right? So in the first 6 months of 2025, when the rules have been notified, April 2025 to the next 6 months, at least you have a consent governance in place, you have your policy procedures in place, you have your data principal rights management in place. And in the next 6 months, and simultaneously you've started your data discovery exercise, which is going to be at least a 6 or a 9 month exercise for an organization of a medium scale, right? And you've started that, and at the end of the 9 months or the end of the 12 months mark, you can do an assessment of where it is, what is your maturity, where have you come up, how much more integrations or how much more processes you need to then build up. And then this will also develop your audit trail. So in case there is a shorter enforcement timeline, you can then demonstrate that you started your efforts, and you've demonstrated your intent to comply. So even if you take, say, maybe you're not able to match the deadline that is provided, which you need to kind of enforce, but for some unforeseeable circumstances, that is that on that day there is something that you cannot kind of say that I'm 100% ready. You still have this documentation to fall back on, saying that these were the extenuating circumstances because of which our very well defined plan kind of got delayed, or so on and so forth. And therefore, we can then, because the law also very clearly states that a 250 crore penalty, which is the highest penalty, it's not like a flat penalty, right? The Data Protection Board will give you a chance to prove that you did everything within your control to prevent that breach or to mitigate that breach or to comply with the law. And the penalty will also be kind of, you will be given that much of a breather to kind of say that there will be some sort of an offset there, which will say that whilst yes, you tried to do it, but because it is not 100% possible at all points in time, we're going to let you go with either a warning or a lighter penalty this time, so that you can kind of continue doing your business and improve upon your compliances. So I'm mindful of the time. I can talk a lot about the implementation plan, but I think this is how you kind of break it up and take it forward.
So that thing, about the time when I was looking through the chats and some of the questions, and obviously some of the many of the questions which have come to us directly, I think we need at least one more day session to even
Absolutely.
try and address all those. But I think there's a lot of insight which we have tried to cover. But let's be mindful of the time, and we try and cover this one slide, and we'll
Sure.
wrap up our session for today. But I think we should do a follow-up session on this. There's a lot which is yet to be covered.
Sure. Okay, cool. So key industry concerns, and this is something that we've brought in. We've brought in through a lot of the conversations we're having with our clients. So how do I create consent notices for 100-odd customer journeys? Please onboard Privy by Edify, and we will do all of this for you. But jokes apart, the way to do this is basically you first need to know what data you hold about them. So do a readiness exercise, do a record of processing activities exercise, or do a current state gap assessment kind of an exercise, and identify what consent notices need to be identified. The notice needs to contain what is the personal data processed. It needs to contain the purpose for which it is being processed. It needs to have a grievance redressal mechanism input from the Data Protection Board, which obviously will come in once the board is in the picture. And it needs to have details of who to reach out to in case they have any queries regarding the data processing. So make sure that you have all of this data available in some shape and form, which you can then kind of build into your notice. Right granularity, again, speak to your legal team, speak to your compliance teams, speak to your business teams, get a consensus on whether you don't want to overkill it by saying that each and every minute purpose is kind of hacked out, because that will defeat the whole purpose of kind of giving the power back to the data principal, because the notice will run very, very long. It will have a lot of legal clauses and jargon, and which will then again kind of not make it not accessible, and therefore not good notice. So strike the right balance in making it easy to read, but at the same time, it should not be so broad that you are just like, for one, saying that we will do all activities with your personal data and that's about it, right? That the person doesn't know exactly what they're using for. So balance needs to be brought in over there. How do I manage data security? If my consent governance platform starts storing personal data, your consent governance platform should not be storing personal data. So whenever you look for a consent governance platform, one of the requirements should be that they should be data blind, and they can do this. They don't need to see what personal data is being consented to. They just need to know what type of personal data is being consented to. They just need to know the name, email ID, phone number is being consented to. They don't need to know what the name, what the phone, what the email ID is, so on and so forth. How can I redesign my physical journeys into digital journeys with built-in privacy notices? Brilliant question. But this question is basically more to do with your digital transformation. But again, you can have mechanisms in place to collect consent. So you can have a physical journey, but the consent is collected either through an IVRS or through a link or through an SMS, wherein they can then exercise their consent, yes or no, through a message output. Data processors. How do I ensure my data processors comply with data principal rights? 3-4 things. Ensure that your contracts are watertight, ensure your contracts have audit clauses, and then go and audit them. That's the only way to ensure that your data processors are kind of going ahead and maintaining all the privacy rights that are there. Integrations and post onboarding support. How can I achieve seamless API integration with minimal latency? I would rather leave this. I wish I had my technical counterpart on this call to kind of answer this. But what limited I can give you is that the consent governance solutions that are there today around are low code or no code solutions to a great extent. They are all SaaS based multi-tenant platforms, and because they are data blind, you can kind of approach them as a service provider without the data leaving your environment, right? And then they can come ahead and it can be a very easy integration because it's a SaaS based platform. So the integrations are so much more easier. Concerns for tomorrow. How does the consent platform support evolving regulations like the ones coming out from RBI and IRDI? The law very clearly says that if there is a regulation or if there is a law which is more strict or stringent on the same topic, then that stringent law has to be kind of a given preference. Or if I rephrase that, both the laws have to be read in conjunction. It cannot be that if the DPDP, for example, allows for international data transfer and there is an RBI guideline that requires data localization, the law has to be read in interpretation of the RBI regulation, which means that localization will have to be given preference to, even if the DPDP says that you can allow transfer of data outside. But with the rules coming in, and I think Neera can come in over there, that restrictions are going to be brought in for seamless data transfers as well over there.
Yes, Pooja, that I already covered in that.
Yeah.
It's very clear for the SGFs
Correct.
that central government has already restricted that certain type of data cannot be transferred. And obviously, there is again the rule that central government has the power to determine the requirement that should be met by the data fiduciary for transferring the data outside. And as you rightly said that as far as when there are two laws are applicable to a particular organization or a data fiduciary, he has to abide by the more stringent one to stay in compliant with the stay in compliance side. So that's true.
Yeah, true. So I think that covers it. One last question is, I think DPIE assessments for my processors based on their risk category. Yes, absolutely. But then at least for the first couple of months, make sure that you are covering all your data processors in some shape and factor, because any breach from your data processor, even if they are holding one or two data elements, because we don't have jurisprudence yet, but you will still be kind of, you may have to face the music on that. So at least for the initial first couple of years, do ensure that you're covering maximum of your vendor base. And as the law matures, as the jurisprudence comes in, maybe you can take a more a risk category approach where the low risk vendors can then be kind of, the audit scope can then be managed accordingly.
I think let's skip this because most of this we have already covered in the discussion. I just want to conclude with two follow-up questions. We are ISO compliant. Are we DPDP compliant? And I can relax. Okay. We are GDPR compliant. Can I say I'm DPDP compliant?
No, definitely not.
I think there are a lot of for questions on this, I think this addresses. Now it again requires a larger discussion. Uh, just by saying, and I have, and we are ISO 27000 compliant, or we are SOC 2 compliant, does not make you a DPDP compliant. GDPR, and I would say GDPR is a mother act when it comes to the personal data protection regulations globally, but every country within Europe also has their specific regulations. So if you know GDPR, that doesn't mean in for that country you are compliant with everything. You have to know the local regulations for that particular country and comply with it. So if you are a global entity, you say we already have implemented GDPR, or you are a Indian MNC working in multiple countries, and you say, oh, we have already implemented GDPR. Now we don't have to worry about it. No, I think the answer is no. You have to still understand DPDP, understand how the implementation will be done. So it's a great journey ahead. And as I mentioned, I think I just realized 1.5 hours is not sufficient to do justice with this topic. It needs a very broad discovery discussions. And again, as Pooja rightly mentioned, there is no jurisprudence right now. There, we don't even know what exactly will come up, because these are still draft regulations. Uh, there are a lot of ifs, but I think the government has set the roadmap for us that this is non-negotiable. It has to be implemented, and I think we have to. It's just about the fact that we have to start um, getting conscious about it and start thinking about it. More importantly, start taking this as a discussion in the right forums, which could be a board also. If you are dealing with with specifically consumer data, uh, B2C, while as Pooja mentioned, and Neera also specifically talked about it, no organization is untouched by it. Okay. So if now they can see you are a manufacturing company, I don't have to be worried about, my board doesn't have to be worried about it. No, it won't, it is not true for you. But if you are specifically, dealing with a large consumer data, B2C business, you should be discussing it not just within team meetings, but in the board meetings also. Uh, Neera, just want to ask you any concluding remarks from you.
Sure. So I would say just 3 points from my side. Now here, the early adoption is the key. As early as we start, you will be ahead of journey. Second, technology and automation will play a crucial role in managing the whole, the framework of or all the regulations that are there under this law. Third is the cross-functional collaboration within the organization. It's legal, IT, HR, compliance team. Everyone has to work closely to ensure compliance. It's not the one person responsibility. So that's a bit from my side.
Thank you, Neera. Pooja, coming to you and concluding remarks.
2 words, I concur. Whatever Neera said, absolutely spot on. Do that and you should be good.
Great. I know we have taken a lot more than what we actually estimated for this, but still I see there are more than 100 people who are still on this call. I would thank you all for your patience, and again I'm sure this was a very interesting conversation. To be very frank, it is a lot insightful for me as well. Pooja, there's a lot which I learned with your conversations. Neera, thank you so much. Always
Could not agree more
you
to this. Yes, it was really very interesting in spite of knowing, but
so
this
I think we
session,
look to
yes.
yeah. Yeah, I said let's do a lot of follow-up follow-up session on this, because this needs a lot more discussion and a lot more awareness, and I look forward to bringing more discussions. And thank you, everyone. It was wonderful.
Thank you.
Thank
Thank
you,
you so
everyone.
much.
Thank
Have a good
Have
evening,
a good
everyone.
day.
Bye bye.